Good evening and welcome to this session of the live learning classes organized by the Board of Studies of the Institute of Chartered Accountants of India. So we go on again today with Prospectus and allotment of securities. I think we have covered a substantial portion of the topic. And if you have any doubts on today's this topic, please feel free to ask me on the query pad, which I will definitely answer. We have seen various kinds of topics. And I also greet those who are here on the query pad. Mamta Yadav, Mohammad Sohail, good evening. And I'm doing very well, sir. Thank you for your kind inquiry. Pooja Gupta, Komal Prajapati, Mr. Prince, Neha Harge, Mohammad Sohail sort of kept asking me, how are you? Which I said, Shantiga, Parthrana, and Ajay Chauhan, Nagaraju, Ramadevi. There's no delay. Actually, I was conducting a one-day corporate training workshop for Indian Oil, and it was supposed to get over at 5 o'clock, but I had a fear that it might run up to 5:30. So I had requested half an hour late. So that is the idea. Yeah, and today's topic is also pretty, we are going to cover this topic fully. So we are going to finish it today. There's hardly something left. I also sent an assignment. So it's not late. Or maybe I scheduled it late. And a lot of people, wow, Priya Varghese, Deepika, Mohapatra ji, wow, so many, I can't keep on telling. Suman Goyal asks a question, what is the minimum subscription? Let us look at that. See, minimum subscription, please note this, Mrs. Goyal, Suman, look at it. See, the minimum subscription is neither 25% nor 5%. I will explain now once more so that you can have clarity. Whenever we make a public issue of shares, let us say that I'm making a public issue of shares for 10 lakh shares. 10 lakh shares. Now, suppose I'm taking the entire money in one shot, for example. So 10 lakh, 10 rupees share, 10 lakh fully I have to collect. So 10 lakh, okay, I'm making, which into 10. So 10 lakh into 10, 100 lakhs. 10 lakh is 1 million. Yeah, 10 million shares. 10 million rupees. Okay. 10 million rupees. I will, 10 lakh, 1 million rupees into 10. So that's 10 million rupees. I will take it from them. So this is the amount I need to get. That is the amount I have to get. Now, minimum subscription is the minimum amount to be received within 30 days. Currently, that minimum amount is fixed at, please note it, 90% of the issue size. 90% of the issue size, not the face value of the shares. For example, suppose a company is issuing shares I will give an example and I will also use a calculator so that I won't have any problem because I'm very weak in numbers. As many of you might by now have understood, I'm very weak in numbers. I'm not able to do calculations very fast, which is actually a danger for a CA, except that, since I know that I'm weak, see, when a person knows they are weak in something and don't do anything about it, there is a problem. When somebody does know, see, for example, I know that my computational skill is low. Therefore, what I will do now, I will take double care. So I will use a calculator. I will recheck when I'm writing the exam, costing, tax, income tax, accounting and all. After I do a column of total a column quickly, I will use the calculator, verify it correctly, and then only I will go. So a little bit more care needs to be taken. That is all. When you know where you are weak and you work on it, no problem. When you know where you are weak and you don't do anything about it, then that is very dangerous. So coming back to the point, minimum subscription is currently fixed at 90 rupees. I'll give an example. A company is issuing 10 lakh shares of rupees 10 each. 10 lakh shares of rupees 10 each. Right. So that is 1 crore. I have to collect 1 crore face value. But the price I'm charging is rupees 25. Okay, so the total issue size is 25 into 10 lakhs, right? So that is 2 crore 50 lakhs I have to collect. Now that is the total issue size. Now what they are telling, 2 crore 50 lakhs into 90%. 2 crore 25 lakhs should be collected on or before that within 30 days of the issue of prospectus. So the date on which the prospectus is issued, they will announce the opening. That is called the opening of the subscription list. That subscription list can be kept open for minimum 15 days. But within 15 days, within 30 days of issue of prospectus, you should receive 90% of the issue size. This is called minimum subscription, right? It is not 25. Now, what is this 5%? Now, in my example, the price of the share is 25, which they are collecting fully at the time of application. Fully at the time of application. But suppose they are not doing that. They are only collecting some portion at the time of application. Then, let us say that they are collecting nominal value, or let us say that they are collecting something less than the price. Then, that amount which they are collecting at the time of application shall not be less than 5% of the nominal amount. So minimum they have to collect. Nominal value is 10 rupees. 5% is of 50 paisa. That minimum they have to collect. Otherwise they cannot less than 5% of the nominal amount. This is the minimum they have to collect from the on application. Got it? So this is the whole thing. So many of you are asking me how I am. So you can actually see me. I'm fine. Thank you. So I have answered, I hope, Suman Goyal's question. Moving on, I'm just looking at any questions. Is there any term called specific securities? Specified securities are there. Specific securities, no. Specified securities are there. Not relevant for you. Not relevant in this topic. Specified securities are there, but not relevant for you. That is securities which are specified for certain purposes. Specified securities, not relevant for you for this topic. Specific, no. Specified, issue of securities will be in a price band. Then how minimum size is calculated? Absolutely correct. The price band is there only till the time of allotment. So that, okay, if you're going like that, it's not as if it is difficult. Your question is asked very correctly. In case you are having a price band, the 5% of the minimum is there, no? That you have to take it. See, if you are going to select the minimum, then your price cannot be less than 5% of the minimum. Moreover, this is not about the price, Baba. This is 5% of the nominal amount. Nominal amount. Also, the issue size will not be known, as you rightly say. Okay. But at the time was, see, I will issue a red herring prospectus. Once the red herring is over and the price discovery is over, I will issue a fresh prospectus. From that date, within 30 days only, you have to get 90% of the issue size. When I'm issuing the red herring prospectus is issued, price discovery is over, I'm giving a band, price discovery is over, then I will again file a fresh prospectus with that final decided price. On that price, within 30 days, I have to get my 90% of the issue size. It's not very difficult to do, to calculate. So, but that's a good question. What happens if there is a price band? See, the price band is not, it's not as if you can all apply at one lower band, I will apply at high. Everybody will apply at different prices in that price band. Finally, the SEBI company and merchant banker, lead manager, they will finalize the price, announce it. Then there will be opportunity for withdrawal also for your information. As you know, once the information memorandum is filed, then after the red herring prospectus, you still have time to withdraw. Then if you don't withdraw, then allotment will be made at the finalized price. Got it? So that money should be 90% of that money should be received within 30 days. Okay. Okay, I will check up on this and get back about the specified securities. I will check up on this and I'll get back. I'm sorry about that point. I'm slightly caught unawares on this. I will check out on this and I'll get back to you. On specified securities, whether there is, if there is 25%, I'll reconfirm it very shortly. That's a good point. Thank you. I'll just check up and I'll get back to you on this. Sorry about that. I'm not aware of this. And I'll definitely get check up and I will get back to you on this. Okay. See, after the return of allotment is made, you have to, Mr. Pai, you have repeated the question many times. Maybe it was done because you thought it is submitted, but you thought it was not submitted and you kept on submitting. So what has happened is many questions have come. So, yeah, Ankur Patel, I will answer you. I will definitely get back to you on that, Ankurji. My mistake. I'm not prepared for it, but I will look up and I will tell you. If not in this class, next class I will. Hopefully you will attend on 5th. I will at that time tell you. Okay. If not today. See, the PAS3 form is called return of allotment. Don't worry about the content of the form. You are not expected to know the content. What is this form? After the allotment is made, you will have to file this form, which is nothing but details of the persons to whom the shares have been allotted. This is called return of allotment. Got it? In those days, it was called form number 2. Now this is form PAS3. It is nothing but basically the form will mention when the allotment was made, on which date the issue opened, when date the closed, and how much was received, and how the allotment is being made, and to whom it is being made. So clearly you will give application number, so much shares allotted to X, Y, Z. That's all. So that is called return of allotment. This return of allotment for a listed company will be filed by the registrar to the issue, who would be a outsourced agency who will keep track, because most companies will outsource this to some agency, or else they might have their own secretarial department who will do this. So whenever a company makes allotment, whether on public issue or not, form PAS3 is not only meant for public issue. Even if it's a closely held company, private company, public company, you have to file form PAS3. Whenever shares are issued, applications are received, and allotment is made, you have to make an entry in the register of members, and you have to file the return of allotment with the registrar. Okay? In case you are receiving money, no problem. But in case you are allotting shares for consideration other than cash, then there should be a contract. See, suppose Mr. A, instead of giving money, is giving you land. So you have to enclose the relevant contract. Also later on in final, you will see that when such a contract is entered into, then you also have to do a valuation through a valuer and get approval of shareholders and all that. So the point is, where it's other than cash, then that form PAS3 should also be accompanied by a relevant contract to be attached. So that is how it is. Thank you, Mr. Pai. Moving on. I feel a little guilty about Ankur's question that I'm not able to answer it straight away, but that's okay. I will definitely get it. So let us now move on to the topic we started, which is misstatement in prospectus. Just give me 1 minute. I will type in something and I will. As I told you, there are 3 types of things. Liabilities could be, civil liability or criminal liability, or there could be general compensation also. Okay. Right. So moving on. Criminal liabilities, I already told you, is a punishment. See, some people have returned a certain allotment. They have filed they have made certain allotment. They have issued a prospectus. That prospectus contains a misstatement. We already discussed this misstatement in the last class. Somebody is asking whether I can watch this video, this session, and though he has not attended the earlier session. Okay, so that I don't know. You can watch, continue to watch, because misstatement in prospectus you can watch, but I still suggest that you download those videos and watch them. Okay, so that is something, it's up to you to watch it, because it's like, hey, I'll tell you what, you are watching John Wick 3. See, John Wick 2, John Wick 3, then you have John Wick 2, what is that, Parabellum, then John Wick 3, then John Wick 4 recently it came. Now, if I want to watch John Wick 4, what I did, I binge watched John Wick and up to 3. I binge watched it, and then my son and I went for John Wick 4 part, which recently released. So better you watch the earlier videos, and or else start attending from the next class. Okay, it's the choice is yours. I leave it to you, so you can continue, because anyway we'll be getting into private placement and all that, which afresh you can learn. But some of the topics relating to prospectus allotment have been covered in the last 2 classes. So you might want to go back, and I think the videos are downloadable. Spend some time watching them. Thereby this will become a little more clear to you. But basically this topic is independent. See, a prospectus has been issued, allotment is going to be made. That prospectus contains the misstatement. Misstatement means false statement or misleading statement or incorrect statement or inaccurate statement or omission of material facts. Omission, not telling something which would make which would give me an influence, which would influence my decision if this is not told. Whatever it is a misstatement. So when those people who are responsible for making that misstatement would be liable for criminal liability, be punished under the act. Whatever punishment, see, imprisonment, penalty, the whole thing will be happening under the Criminal Procedure Code 1973. Please note, criminal liability the proceedings will not happen before the tribunal. It will happen before the jurisdictional court. Please understand. See, the judicial system is such that each state has a high court. Now, within that high court, you have district courts. In large cities, you have metropolitan magistrates. And in district courts, you have first-class magistrates. So there will be, every district has a court here. You might have seen in your district also, if you locate it, there will be a district court. So any dispute arising will go to the district court only. If the amount involved is high only, it will go to the high court. Otherwise, it will go only to the district court. Also, if a company's registered office is situated in one district, this will happen in that district court only. Suppose your office is situated in Bavra district, then it will happen there only. That local magistrate, Bavra magistrate only will take up your matter. Don't think that because you are some big listed company, it will happen in Mumbai High Court or in Indore. No, it will happen only in. That is why the registered office is there. Please understand, the registered office is meant to give domicile where the person will be prosecuted. See, if I am residing in Chennai, let us say I have my Aadhaar in Chennai. The address is in Chennai. My Aadhaar is in Chennai. So where will I be prosecuted? Only in Chennai. Okay, where jurisdictional court, which may be Saidapet High Court. I don't know. Whichever High Court comes, first you know how you should locate that. You should first locate which is the jurisdictional police station. Then for that which is again, for me, it's Thenampet E3 police station. If that is the jurisdictional police station, then straight away, that police station will be attached to one magistrate. That will be the jurisdictional magistrate. It's not difficult to find out who is your jurisdictional magistrate. But why am I giving this elaborate procedure? So that you will understand this as not, thereafter MCA is lost. It is the Ministry of Corporate Affairs will initiate prosecution against the offender. And it will go through the court. Are you able to understand? You see, he may be MD of some big company, multi-crore company. Still, he has to come to that magistrate court. In case you don't know what is magistrate court, you have to go there in your city or in your town or your district. You just go there and see that. Okay, my son, as he's an advocate, he's just a junior advocate, 25 years old, and he is going around to all the magistrate courts. Every day he goes to one magistrate court, he goes to one district court, he will go to some local Tiruvannamalai, Kanchipuram, civil cases, he'll argue, he'll do that. He is starting his career. He is learning how to thing. So straight away, MD, our MD will not come to local high courts or local courts. He'll come only to, you have to go there. And you know who will be standing there in that court? Everybody here, all offenders will be there. Pickpocket will be there. Prostitute will be there. Pimp will be there. Everybody will be there. Along with them, you also have to go and stand. Please understand, criminal liability is very steep. See, which is why am I giving this elaborate, explanation for you? That's what, Sir Geeta Rani Madam, that is what I am telling. Where will the criminal proceedings liability will be held? Magistrate courts. You are coming from the northern region. I don't know which city or town you are coming from. Locate your own district, local district court. Just go there and peep and come. Don't go too inside also. Just go peep and see how that magistrate court is occupied. There, that magistrate will not know company law and all that. He will simply be a guy who what is the offense? Then he'll have what is the penalty? Okay, what do you want? Do it. Chal. That is how it will be there. Okay. So that is the place where this prosecution will happen. Right. So why I'm giving this now? Never ever commit any offense under any law and expose yourself to criminal liability or penalty, etc. That is why, as a chartered accountant, never even think like that. Civil liability is different. Civil liability also, the jurisdictional court will be based on the registered office of the company. Please understand, it is the registered office which decides the liability jurisdiction. So that is why registered office is very important knowing. Because if you serve it, let us say that a company has a huge office in Mumbai. If that is not the registered office, as I told you, the registered office is somewhere near Nagpur somewhere, then Ramtek or something, then you have to go file there. You have to file in that local district only, you have to file. Okay, the district magistrate will, unless the amount is very high. I think pecuniary, I think it's 1 crore. Then you can go to the Maharashtra High Court. Maybe there is one High Court in Nagpur also. Okay, or maybe sitting in Nagpur, I don't know. Definitely Pune may be there. And Mumbai, there is one. There will be a High Court which is sitting. See, for example, in Tamil Nadu, we have a High Court in Madurai. Earlier, we had only one High Court, that was Madras High Court. But now, we don't call it Chennai High Court. We call it Madras High Court. And we have there is one more High Court in Madurai. High Court, proper High Court is there in Madurai. Okay. So the point I'm making is, depends on the jurisdiction. So that is one thing. You and I are chartered accountants. We are not advocates. Why break our head? But general knowledge, you should know now. Even when you're talking to an advocate, see, as a tax practitioner or a tax expert, you will have to definitely brief lawyers and advocates on and off. You might have to get a stay. You might have to go for a writ petition. You might have to, go to court for injunctions, whatever. In those cases, at least you should know minimum about procedure and things like that. Right. Now, civil liability is where those people who have relied on the prospectus, who have read the prospectus, and based on the prospectus, they have invested the money. Later on, they find that false statement has been made, because of which newspaper reports are all coming, the market collapses, the price collapses in the market, they lose money. Then that loss or damage should be compensated by those people who are responsible for the issue of the prospectus, not the company. The company is not liable. Company is an artificial person. Who did it? The promoters, the directors, those people who have authorized the issue of the prospectus. Every expert, everybody will get affected. Okay. So civil liability is an offense against the counterpart. Right? See, in the institute material, there is a lot of stuff. Please go through it at your leisure but basic ideas I'm giving here, which is relevant. Now, section 36 is a slightly unconnected section. I'll cover that. I forgot, sorry. Neha Garge is asking. Mens rea is a very, very important concept in criminal liability. See, there might be an offense. Okay. But was it done with intention? Guilty mind. Was it done with intention? That is the correct Neha. Yes, intentionally. Was it intentional? Okay. So, normally in criminal liability, mens rea is to be proved that there was a guilty state of mind. So, premeditation has to be proved. Okay. For example, if a murder is committed and one of the close relatives of the dead person suddenly runs away from the city, that is a clear example that he's guilty, and otherwise why would he run? There is a premeditation, there is a plan, there is a intention to cheat and defraud. So premediation is called mens rea, or intention. Okay, intention is very important, but with one or two exceptions, criminal liability, you have to prove guilty state of mind. See, otherwise the punishment will be different. See, Mr. A is having an uncle. Uncle is 72 years old, worth 500 crores. Now, what A does, every day he gives uncle coffee, PJ, he gives coffee. Little bit of arsenic is adding to that coffee. Little bit of arsenic. Arsenic is a very deadly poison, slow poison. So, over a period of 3 months, uncle is complaining, I'm having stomach ache, I don't know, oh my God, uncle, like this, like that. Finally, uncle dies. And nephew, he is the only man, his sister's son, he is inheriting everything. The uncle has no children, everything, he is getting 500 crore. Now, later on, it is discovered that this fellow only did arsenic poisoning. Now, this is not premeditated. You wanted that man to die. Every day you have been giving him arsenic so that finally he will die. So this is example of premeditation. Thinking before. The intention itself is to cheat. So if that is proved, then it is a very, very serious. When you come to 447 now, we will be seeing that now. Punishment is very stiff. Because you see, we are living in a society in which innocent people and ignorant people like me have to be protected. Am I correct? How to protect? See, if criminals can come and cheat innocent people like me, should not happen. And if they are caught, the punishment should be so severe that next time somebody should be thinking 100 times before cheating. See, sometimes, I find the type of tough punishments which are prescribed now in some of our traditional methods may be correct. Maybe that's the way it should be done. That will be a greatest threat for somebody to think, am I correct or not? In fact, you remember I told you that story about Prospectus and how I gave 50 rupees. That is example. See, that was a penal section, 50 rupees. But for me at that time, 50 rupees was not a punishment. It was a permission. I could say 50 rupees, now take it. Allow me to do it like that. Now the point is, so the punishment should be so tough, which is why when that same ROC, he became a director in the ministry, then Ministry of Corporate Affairs. And he was asked to draft the Second Amendment Act. The Companies Act was extensively amended in 1999. The 56 Act was extensively amended in 1999. There was an ordinance. He was drafting it. So the first thing he did was, he went to the Prospectus section and he changed it to the minutes section and he changed it to 500 rupees. In fact, that entire penalty was increased to 500. But unfortunately, see, I have met him in 1999. Sorry, I have met him in 1994. This happens in 99, 2000. When I go in 2000, 500 rupees is no common. I said, sir, 50 rupees in those days equal to 500 rupees today, sir. Again. But now you go and see that section, minutes maintenance, it is 50,000 rupees per minute. For every meeting, it is 50,000 rupees. That is, I am not worried because 50,000 is not easy to sacrifice. So the punishment should be very tough. So now, this 36 is a section where, see, I have read one person was wanting me to repeat the calculation. Mr. Jha said, Mr. Jha, just wait. When I come to one point, I will go back and explain. So, yeah. You are watching John Wick 3 and you don't know why he loves dogs. No, I don't know. Seriously. I don't know why he loves dogs. I know that it all began with a dog. I know that it all began with a dog. Because they shot his dog. I don't know why he loves dogs. Maybe is it because of his wife or something? Because his wife dies and that dog possibly belonged to her or something like that. I don't know. Honestly. I know that somebody shot the dog. And that's why this fellow goes on a rampage. And I enjoyed Keanu Reeves. I enjoyed that movie. And I give that example. I don't know why he loves dogs. I know that he loved that dog, but I don't know why. Chalo. Now, section 36 is it's actually an independent section. It has nothing to do with per se with prospectus, but they include it here because anyway they are prescribing punishment. See, whenever any document or any notice or circular is given to the public with intention to collect money from them by way of subscription, punishment is there now. So since prospectus is a well-known case, they have put it there separately. Here they are saying any person, here the punishment is not for company, it is for a person who either knowingly or recklessly, knowingly means premeditated, recklessly means without any care for other people. See, you are having a Ferrari car, okay, evening 11 o'clock in the night, you come back from the nightclub, drunk, and you drive. It's reckless. That is called reckless driving, okay, where you are not bothered about the safety of other people. So you knowingly or recklessly make any statement, promise, or forecast about the future, which is false, deceptive, or misleading, or deliberately conceals any material facts. So false, deceptive, misleading. We already saw what is false, outright lie. Deceptive, made to look at it, but once you go there, it will be gone. Or misleading, or deliberately conceals any material facts. To induce another person to enter into or to offer to enter into any agreement for or with a view to acquiring, disposing of, subscribing for, or underwriting securities. So, if you are giving this is nothing to do with prospectus. You are simply sending a letter to people saying, Dubakur Limited is a great company. We have already acquired shares in the company and we are willing, just because we love you, we like you, you are a good boy, and we know that you need a break in your life. We are willing to sell these Dubakur Limited shares, which are worth actually 500, 600 rupees. We are willing to sell it to you for a measly amount of 100 rupees. Why? So there are many reasons why we are selling, but bottom line, you are getting a 400 rupee profit straight away on the table. Sir. Take it or leave it. These are all misleading statements meant to induce a person to enter into or get into a contract or agreement for acquiring or disposing of or subscribing for or underwriting securities. See, this especially happens for unlisted companies. I tell you, it's a very big danger, where some promoters of unlisted companies, they need to get money, promoters' contribution. Therefore, what they will do, in order to increase the equity base, they will go to the people and they will take money by making false statements. Okay. So, any person who does this, okay, or you are making this type of false statements with the view to inducing that person to enter into or offer to enter into any agreement, the purpose of the pretended purpose of which is to secure a profit to any of the parties from the yield of securities or by references to fluctuations in the value of securities. See, this, I tell you, we are now in 2023 end. Believe me, and if you don't ask me how, why, please do not ask me how, why and all. I don't want to, the time is not there. 100% market is going to go up. 25, 26 will be the peak. Unimaginable height this market is going to go, means from where it was in 2019 or 2018 to now, it's going to be a huge high in 25. So the point I'm making is, now is when all these dirties will come out of the woodwork. The worms will come out of the woodwork and they will start sending letters to all innocent people saying, make money in the share market. You don't have to know about it. We will tell you how to do it. Enter into an agreement with us. Buy the share, we tell you. Or give the money to us, we will buy it for you. Portfolio management. All this is controlled by SEBI. So without SEBI's knowledge, if something is happening, that is fraud. Okay. But believe me, people are going to madly go and put their money in these scams. I'm telling you, it's going to happen. Because when the market is in a boom now, everybody becomes greedy. So they will go to these people. So when they see the advertisement, they will. So that such an advertisement is given, immediately Ministry of Capital will look at it. Hey, this advertisement looks a little worried. Call that fellow. Who are you? What are you promising to give? How are you going to give the yield? What assurance you have? That fellow will get caught. And then once this happens now, then straight away they will take action under section 447. Any agreement for or with a view to obtaining credit facilities from any bank or financial institution. They have included that also. So suppose you give a false balance sheet or false projection. Do you notice it? They have also used forecast. False makes any promise which is false, deceptive or misleading. Because forecast cannot be false or true. Why? Because forecast is a forecast. How it can be false? But it can be misleading or deliberately concealing a material. It can be misleading. Therefore, you should, if any of these three is proved, then meaning simple was, any person is sending any letter or statement or promise, or he's giving some projections and all. Idea is to make you buy shares. Either buy the share or subscribe or sell the share also. Okay. Or inducing an underwriter to enter into an underwriting contract with us. Whatever it is, that person is doing it by making a false statement. Like that. Similarly, any method of, for example, see, there are a lot of people who are going to come out and say, I'm an expert in trading in Nifty, on Nifty. Nifty itself he'll buy and sell. Nifty itself he'll buy and sell. So you give me 25 lakhs. I will take 30% of the profit. You take 70. I will do it for you. And if you give me 25 lakhs, now by the end of 1 month or 2 months, I'll make it 50. Double it. 1 crore, like that now. Oh, wow. So somebody, immediately he'll go, good, in a decent way, they would have invested in the post office savings, which would have given them, senior citizen would have got 9%. So this gentleman will break that amount, bring that money and give it to this fellow. So to protect them, the MCA says, if such letters are being issued, they will call this fellow and ask, what are you doing? What guarantee you are giving? Are you registered with SEBI? What is your role? Like that. So in case they are proved to be guilty, then they shall be liable for action under section 447. 447 also I'm going to explain to you. See, I'm going to deal with 447 in a very short way. A suit may be filed for any action may be taken under the section 34, 35 or 36 by any person, group of person or any association of persons affected by any misleading statement or the inclusion or omission of any matter in the prospectus. See, 34 criminal liability, 35 civil liability, 36 fraudulently inducing people to invest. Any of these matters, one person can take action on behalf of everybody. This is called class action. See, where there is a group of people, all of whom are suffering from the same problem. See, Dubakur Limited issues misleading prospectus based on which these fellows buy share. Subsequently, Dubakur Limited folds. Matter of 1 month after listing, company disappears. Automatically, share price from 350 rupees, it comes down to 3 rupees 50 paisa. Where? Gone. Am I correct? It's now 3 rupees 50 paisa. So 348 rupees 50 paisa gone. I'm sorry, 341 rupees, what is that? 346 rupees 50 paisa gone. Okay, so this fellow have what to do? Fellow has to cry. So he finds that more fools are there in that category. So together they form one association. What? Dubakur Limited Shareholder Association. And they decide to. So now that association on behalf of all these fellows can file complaint. So a suit can be filed. This is called class action. So obviously because everybody may not have the time. So on their behalf, the association will be formed. 100 fools like that. I'm sorry to use the word fool. 100 great people who are highly intelligent, brainy people. They will all come together and they will form this association. One fellow will become president. Another fellow will become secretary, treasurer for this stupid association. Secretary, treasurer fellow will be there. They will drink coffee, tea, eat vada, keep arguing. I don't know what is happening to society. All these chartered accountants are the problem for all these things. They are only supporting these criminal people like that. No, they'll talk nonsense. Finally, nothing will happen. But they can file a suit, and on the MD and other people, they'll file a suit. That the MD by now would have been in Antigua or in Switzerland enjoying that. He won't be in India. Fellow will be in Antigua, which is in that Bermuda. There is that Jamaican island. Near Jamaica, he'll be Caribbean island where he'll be enjoying his life. Whereas these fellows will be sitting, drinking coffee, in Woodlands Hotel telling all this problem is because of our chartered accountants. They are all criminal. They are the criminal people. Everybody laughing and going about their business except these fellows. But whatever it is, the class action can be filed. What is a class action? When a group of persons are affected by a misleading statement, any one person on behalf of the group or an association of persons which is formed, association of persons, can file a suit. And the advantage is that suit can be proceeded by people who have time. Those who don't have time will sign the petition, that whatever it is, authorize them and give them 1,000 rupees or 2,000 rupees for the legal expenses. Then they will hire some big advocate, file a suit, and at least a matter will be going on. Finally, if there is any money, maybe the company goes into insolvency, some assets are realized, so the tribunal orders so and so. Then they will move the court. Court will direct the tribunal, or court will direct the insolvency professional, resolution professional. These people have suffered, pay them. So when that money comes, it may not be the actual loss claimed. Some amount will come now. That has to be distributed amongst all these people proportionately. Finally, that one person may get 350 rupees, 400 rupees. The coffee expenses would have been more than what he recovers. But still, there is some satisfaction that I have taken action against such people. So, this is what it is all about. And if the time permits, we are running MCA notification dated, making dematerialization compulsory. Mr. Suman Goyal, dematerialization will be covered in detail in the next topic, share capital and debentures. Okay, dematerialization as a topic will be covered in detail in next topic. At that time, I will take up and I will give you, okay, about this, whatever that MCA circular, MCA notification dated 27 October 2023. Okay, 27/23. Yeah, actually there is a new thing. I will definitely cover it. When I come there, I will definitely cover the topic on dematerialization of shares. Thanks for the question. Well noted, and I will cover that. Okay. Where to get deep knowledge of share market and trading from zero? I don't know, sir. If I know, I will do it now. So I'm not aware. I know one method, which is reading the balance sheet, understanding the business, investing in good businesses, etc., which I learned over the last 20 years by investing, by learning, and by reading. And all. That takes a long time. If there is any easy method, if you know, you tell me, I will learn. That is easy. Deep knowledge, nobody can get. All of us are fools only, but some are slightly less foolish than others. When it comes to share market, there is nobody who is intelligent, nobody who is ultimate authority. Even Warren Buffett agrees that he has made some mistakes. Yeah, reading books will help you. Start reading now itself. Start taking up reading some good books are there. Just begin by reading Rich Dad, Poor Dad. Then slowly gravitate, move on. There are a lot of books. Read books about Warren Buffett. Okay. And become a chartered accountant. That itself is one easy way of understanding the financial side of share market. Becoming knowledgeable. Become a chartered accountant. Then slowly, when you come to, I think intermediate itself or final, you will learn valuation. Discounted cash flow method of valuation. Intrinsic value. All that. So you just learn slowly. There is no method. Currently, don't get into that. Finish your CA, then you can do all these things. Okay, my humble sir. The exception for misstatement. Correct. There are some exceptions. We'll come to that. Okay. When is the liability? Criminal liability happens when the prospectus is issued, circulated, or distributed under Chapter 3. It includes any statement which is untrue or misleading in form or context. Any statement which is untrue or misleading in form or context, any inclusion or omission is likely to mislead. Who is liable for criminal liability? Every person who has authorized the issue of prospectus. Every person. And the penal liability, for criminal liability, the penal liability is in 447. Okay. Now, question asked Jeev is Mr. Nagaraju is this. Who will be any exception for misstatement? Yes. Knowingly or unintentionally or unintentionally. See, where the person who is liable now, who is authorized the issue, if he is able to show that that statement or omission was immaterial, that is not something which would have influenced the decision. That is not something which would have influenced the decision. Such an insignificant thing. For example, one of the statements in the prospectus is the coal industry in India is expected to grow. The coal, see, this company may not be in coal, right? But they may be in the coal value chain. So, or maybe coal is an input for them. Okay. But what is that statement? The coal industry in India is bound to increase by 3 times in 2035. Maybe the newspaper report that they would have quoted that. There it might have said, instead of mentioning 3 times, it might have mentioned 2.98 times or 2.5 times. 0.5 times it will be your misstatement. Okay. Because of that, how the calculation would change. So, such cases, it is immaterial. If so, they will say no criminal liability. Also, honest belief. That person had reasonable grounds to believe and did, up to the time of issue of the prospectus, believe that the statement was true or that the inclusion or omission was necessary. See, but proving honest belief is very difficult. But as rightly said by Nagaraju, unknowingly or unintentionally, a misstatement has come. I honestly believed it to be true, Baba. I honestly believed it to be true. Then you can escape criminal liability. But if finally liability is determined and you are saying you are liable, then the punishment is prescribed under section 447. What is that? Where the fraud is less than 10 lakhs rupees or 1% of the turnover, whichever is less. You calculate amount. Less than 10 lakh. Now calculate 1%. Suppose that amount is small, then that amount, if it is more than 1%, but less than 10 lakhs, still covered. Okay, fraud. Suppose the turnover is 80 lakh, 8 crores. Then 1% will become 8 lakhs. 1% will become 8 lakhs. Now that 8 lakhs is less than 10 lakhs, but 1% of turnover, therefore covered. So if the fraud value is 8 lakhs for an 8 crore company, still 1% covered. So it's either 10 lakh rupees or 1%, whichever is less. So you calculate 1% of turnover, 10 lakhs. See what? Whichever is less has to be taken as a limit. If the value of the fraud is less than that, then up to 50 lakhs fine. Up to means fine need not be charged. Up to, because 0 to 50. Or, so there is an option, fine or imprisonment up to 5 years. This or is very, very powerful. Why? Because if there is an or there, then you have a chance to go to the regional director or the tribunal, fall at their feet and go for compounding, so that you need not go before that high court. If you go for compounding is a procedure. Listen to me. I'm explaining what is compounding. Listen to me. If you go to the regional director or the tribunal, depending on the amount of the penalty, the regional director and the tribunal have the power to go to the court and say, hey, we are compromising with this gentleman, so kindly we are withdrawing the case. Please note as acquitted. Come. So you will not be found guilty. The court proceeding will be withdrawn and you have to pay compounding fee, which will be very high. It could even be 1 crore for 50 lakhs. But at least you have a chance. You might think, I'm paying 1 crore. Sir, who is paying 1 crore? That person is the MD of Dubakur Limited, one of the top persons in the country. If he is found guilty, thereafter he can never go for a public issue. He can never be a promoter of a company. So, better avoid that now. 1 crore is nothing. Pay it and go and compound the offense. Of course, compounding is not a right. It is an that a regional director or tribunal, as an option, they can give if they feel that it is a deserving case. See, there could be a genuine case where a promoter unknowingly did it, but it is guilty. He is guilty. He is not able to prove honest belief, but still, man is honorable. So let's go for compounding. But If the fraud is equal to or more than 10 lakh or 1%, then the penalty is the amount of fraud. Suppose the fraud amount is determined at 3 crore, penalty is 3 crore. 3 times the amount of fraud is the maximum. Suppose the fraud value is determined at 30 crores. Dubakur Limited scam, 30 crore. Then 90 crore is the penalty. In addition to that, civil liability will also be there to those people who have suffered loss. And this and is very, very important. You cannot avoid, you have to go to court. You have to go to court and stand, and they will find you guilty. Then you can only, at best, you can go on appeal. You can go from the district court, you can go to the high court. From high court, you can go to the Supreme Court. That's about it. By then everything would have, maybe by then, 30 years. So if that gentleman is 40 years old, this whole proceeding starts, by the time the proceeding gets over in Supreme Court, it will be 25 years. 40 plus 25, 65 years. After that, if they charge, at that time you can go and tell, he's a very old man now. Kindly don't imprison him, or minimum imprisonment 6 months, let him go and come. Thereafter, you let him go. Fine, fraud, we will pay. Like that and all, you can bargain and get out of the situation. Now, see, sometimes the way I'm speaking, it may sound as if I'm being sarcastic about the judicial system or about the legal framework. It is not sarcasm, it is pragmatism. The reality of today's judicial system is like that. So, maximum term indicating up to maximum amount, maximum amount is 3 times. Fine ka amount hai na 3 times. Maximum imprisonment is 10 years. 10 years. Okay. Yeah, maximum is up to 3 times. Okay, you want me to change it? Up to? I'll do that. Up to 3 times. You are saying it is up to, I will check up and I will change it. I will check up section 447 and I will change it, definitely. Up to means what? Minimum once, maximum up to 3 times. So they can do 2 times also, 2.5 times also, maximum 3. They cannot go beyond 3. Okay. Thank you for that input. I will, before I upload it, I will change it and I will. Now, suppose the fraud is involving public interest. See, when public interest will be involved, when big notice is given, advertisements are given in the newspapers and wide publicity is given, then that penalty is the amount of fraud or 3 times. But look at the minimum imprisonment for public interest. It is 3 years. And the maximum is again up to. In all cases, whenever a maximum is given, it is up to that. Okay? Within that also, it can be taken. I will check up from the section and I will correct it. Thank you for today. Many of you are doing a good job of pointing out so that I can look it up and then I will make a correction. Okay, up to means minimum amount of fraud. Minimum, it has to be charged. In case they want to do more, then they can go higher, up to 3 times the amount of fraud. Okay, I'll check up if there is an up to word there. I'm sure it is there because you are telling from, possibly you are looking at the institute material and telling, or some other source and telling me. So maybe you're right. They've also defined what is a fraud. Fraud is defined under the Contract Act. Don't worry about that. For the purpose of section 447, definitions sometimes are, for section, there will be a definition. If so, that definition will have to be considered. Fraud in relation to affairs of a company or any body corporate includes any act, omission, concealment of any facts, or abuse of position. Okay. So any act, omission, concealment of any fact, or abuse of position means when the person is in an authoritative position, misusing it. Okay. When he does it, it's committed by any person or any other person with the connivance in any manner with intent to deceive. So if that person is committing it or any other person is conniving, meaning when a fraud is being committed, this other person is simply folding hand and watching. Connivance. See, Mr. A is not committing the fraud, but when in front of him the fraud is happening, he keeps quiet. That is called connivance. Meaning you are a party to the crime, But you are not actively doing it, but by keeping quiet or by hiding, you are conniving, is the point. See, a theft is going on, watchman is quietly going to the tea shop. Knowing that there is a theft going to happen in that house, the watchman who is paid to watch that house, he goes to the tea shop. So that later on, if somebody comes, he can say, no, sir, I went to the tea shop. In the meantime, something happened. But actually, he knows it's going to happen. That is called connivance. Okay. Knowingly, so later on, this fellow will go and get that money and, sort of come back. So the purpose, fraud is any act of concealment or omission or conniving in any manner with intent to deceive, to gain undue advantage from or to injure the interests of the company or its shareholders or its creditors or any other person. So there is an intention to cheat either the company or the shareholders or the creditors or any other person, whether or not there is any wrongful gain or wrongful loss. See, a fraud may not result in profit to somebody and loss to somebody. Even then, fraud is a fraud. Okay? Fraud is a fraud. Wrongful gain means the gain by unlawful means of property to which the person gaining is not legally entitled. It's clear now. I'm not entitled to it legally, but quietly undisclosed gain, illegal gain. See, not in this context, but in general, I'm telling the MD of the company or the professional MD, not the owner MD, employment, the guy who is in employment as the CEO of the company, he cuts a deal with the vendors and he says, I will approve higher rate for you. I will see to it that the purchase committee approves it, but you give me a kickback of 2% of the your total turnover, you give it to me every month. Benami account, I will tell you, you transfer it like that. So clear fraud here is that gentleman is gaining by unlawful means of property to which the person gaining is not legally entitled. See, where the company should pay 5 rupees only, now they are going to pay 7 rupees. That extra 2 rupees, which this vendor is billing now, is going to be kicked back to the CEO's Binami now. So clear-cut fraud now. So in these cases, it's called wrongful gain. I'm just giving an example. But this section 447 is for any type of fraud or anything committed in connection with a company. Okay. Wrongful loss means the loss by unlawful means of property to which the person losing is legally entitled. Please note the 2 words there. In the first case for wrongful gain, they clearly said not legally entitled. So Mr. A is not legally entitled to it, but he takes it. Whereas somebody is legally entitled to it, but they are not getting it. Loss, they are losing it. Okay. Civil liability. Now, who is liable? Directors. Yeah. People who are conniving are also liable. Okay. They are also liable, 100% liable. In fact, in criminal law, this connivance has another name. It is called abetting. Abetting means supporting a crime. In fact, abetting is seen as an even greater offense than the crime itself. Abetting. A-B-E-T-T-I-N-G. Abetting. Now, civil liability. Directors at the time of issue of prospectus. Persons who have authorized themselves to be named in the prospectus as directors. Persons who have agreed to become directors in future. Promoter. A person who has authorized the issue of prospectus. Right? Expert. Everybody is liable. What is the liability? See, here, there is no fixed amount. Whatever is the loss sustained, that amount has to be paid. See, the loss has to be paid, interest has to be paid. In addition to that, damages can also be paid. Meaning, see, when somebody is suffering, they have damage, that also can be paid. So, in addition to criminal liability under section 36, there is a civil liability to pay compensation to every person who has acted on the basis of a statement or omission in the prospectus and has, as a consequence thereof, sustained loss or damage. See, criminal liability even if there is no wrongful gain or wrongful loss, there is a punishment. Even if there is no wrongful gain. But for civil liability, there should be some loss, some financial loss or damage. If you don't prove that, it's very difficult. So, thus, all these persons are personally liable without any limitation of liability and cannot disown, that means reject or throw away the liability by saying that they relied on statements made by promoters, etc. The minute you are named as a director, you are liable. You are named there, not you are given your sign, that's it. You may be Shah Rukh Khan, doesn't matter. You are liable. But some defenses are there. Sometimes you can avoid it. How? If you are able to show that I consented to become a director, but I withdrew my consent, and the prospectus was issued without my authority or consent. How to prove that I withdraw? I have to send a withdrawal letter by registered post. So, before the issue of the prospectus, you should have withdrawn the consent. Then no problem. So you can say, look here, sir, these fellows didn't remove. I, in fact, very specifically withdrew consent and said, remove my name. The rascals have given it without removing. So the tribunal will, the court will go through it. You have withdrawn on such and such a date, registered post. They would have got it. So if they have included a name, that is their mistake. You are cleared. Go. Like that. So this is one defense. Another defense. The prospectus was issued without his knowledge or consent. No person shall be liable. See, I never gave my consent. Are you able to understand? Here, I gave my consent, but before the issue, I withdrew. And the prospectus was issued without my knowledge, without my authority or consent. Now, I don't even know that these guys are putting my name. And without my knowledge or consent, it has gone. I have never given my consent. How to prove never given? I can't prove never given. They have to prove I have given. Are you able to understand the difference? A negative cannot be proved, sir. A positive only has to be proved. Right? So, on becoming aware of its issue, he forthwith gave reasonable public notice that it was issued without his knowledge or consent. Right? As regards the misleading statement purported to be made by an expert. Now, please note, expert does not have many defenses. One defense is, it was a correct and fair representation of the statement. See, where I am relying on an expert. Are you able to understand? I am a director. I have included a statement purporting to be made by an expert in the prospectus. I am liable. But I tell him, sir, it is not a statement made by me. I am relying on a statement given by, purported to be made by an expert. See, this is what he has given. His opinion is here. And I have exactly reproduced it in the prospectus. Whatever he said, I have put there. Or correctly, relevantly, I have put it there. It was a correct and fair representation of the statement. Whatever he said, I have put it there. And I had reasonable grounds to believe, and did up to the time of issue believe that the expert was competent to make it. So that fellow is a structural engineer. I honestly see, we gave me this, I have put it correctly here. And I honestly believe that the expert was competent to make it. I had reasonable grounds. He was competent. Also, the expert had given his consent and the expert had not withdrawn his consent. See, because if the expert withdraws his consent, expert is relieved. But expert has not withdrawn his consent before delivery of prospectus for registration or to his knowledge before allotment thereunder. So expert has given consent and has not withdrawn it before delivery of prospectus or to the knowledge of this person before allotment thereunder. Then the expert will be caught. I am escaping. So I correctly and fairly, whatever he has given, I put it here. I had reasonable grounds to believe that he is competent. He is an expert. He has given his consent. He has not withdrawn his consent before delivery of prospectus, before allotment. Afterwards, if he gives, nothing can be done. Expert is caught. Got it? Now, suppose I am including in that prospectus a misleading statement, which is a copy or extract from a valuation report or valuation of an expert. then whatever I am reproducing should be correct and fair representation of the statement. Correct is okay, means whatever is put there should be put. Fair means what, he might have made statements, but the entire statement should be made. See, suppose he had made one statement, the quarries belonging to the company are rich in mineral deposits or rich in deposits of iron ore and manganese. But extracting them will be very costly. And by the time the extraction happens, cost per ton of pig iron will be very high. You are able to understand. He is saying, yes, there is iron ore there, no doubt, rich, they are rich, but it is situated in such a way that I cannot do strip mining and I cannot go in the depth and get it out also. It's going to be very difficult for me to do it. So the cost of extracting it may be very high. So he is giving a statement with a sort of a condition. Now, while reproducing that, you should reproduce the whole thing. You cannot simply say the quarries of the company are rich in iron and manganese. Report of Mr. Donkey expert, if you put, then it is not a correct and fair. It is correct, but not fair. Because, see, I have also told that it is going to take. So that is what we mean by correct and fair representation. Correct means exactly what is given there. If you put here, it is correct. But the entire thing should be told. Not only one portion. Okay. Also, that it was a correct and fair extract from the report. Okay. You can't take cherry picking words and you can't put it. The entire thing should be given. So the person should be given an opportunity, the ultimate applicant for the shares should be given an opportunity to make an informed decision. So after reading this, rich in iron ore, I make my own calculation. No. This is a dangerous company. I will not invest. I should be able to form that opinion. Okay. For example, as I told you, if the expert has provided risk factors or conditions which may affect his opinion, the same should also be provided. If that is not done, then the expert is not liable. The person who has included it is only liable. Suppose tomorrow they call the expert and ask, hey, what are you giving opinion like this, rich in iron ore? Sir, please read the whole report given by me. Ask them to produce it. I am also giving you. What did I say? I said iron ore, it is still there. Iron ore and manganese is still there. But I also mentioned that extracting it is going to cost much more than the market value of the pig iron. I have told very clearly. Oh, you have told, that's it. So expert go. Promoter come, stand, gone. Now, there are two small problems that we will try to solve. Let me see if you have got it. Friends, I may not give a break today for obvious reasons. We started late, 6:30. So if you go without a break, we can complete it a little early. What do you say? Hardly one more topic is there. After that, we can close it. Some questions I will discuss it and we can close the topic. I humbly suggest that we won't go for a break. Please. It's my humble request to you. Now read the problem and try to give me an answer. So X applied for and was allotted shares on the basis of a prospectus containing an untrue statement. Y purchased the shares from X. Can Y sue the promoters of the company for rescission of the allotment? See, what is the issue here? There was a misstatement in the prospectus. There was an untrue statement, no doubt about it. Who relied on it? X. He relied on it and applied. Thereafter, Y purchased the shares. So, did Y rely on the untrue statement and as a consequence thereof suffer loss? No. So, Y is not liable. Got it? It's called Peak versus Gurney. Peak versus Gurney. Y cannot sue. Beautifully said. This is taken from a very famous case called Peak versus Gurney. Okay. Now, ABC Motors Limited issued a prospectus. Correct. All of you have got the answer correctly. Malavika ji, Suman Goyal, Neha Garge, thank you for accepting that no need for break. Ruturaj Honmane also gives the correct answer. And so ABC Motors Limited issued a prospectus claiming that they would be able to obtain a particular license from the government. The directors honestly believed that getting the license was a mere formality. However, the license was not granted. Can the allottees file a suit for rescission? See, in the case of Derry versus Peak, it was found that there was no intent to defraud. The statement was made honestly, and the directors honestly believed that getting the license was a mere formality. But the license was not granted. So it is not a false or misleading statement. At the time when they made the statement, an application had been made. They honestly believed that getting the license was a mere formality, but the license was not granted by the government. So for that, the allottees cannot file a suit. But today, if a prospectus contains this, the license, an application has been made to the Government of India for a license, and the same is pending, then SEBI will also ask you to say, the profitability projections are based on the grant of the license, which is not certain. The extra statement they will ask you to add, so that anybody reading the prospectus will know that there is uncertainty in the grant of the license. That is more than enough. If such a disclosure is made and you still believe me and buy my share, then no need. If that is not granted later, I clearly told, license may not be granted. I have put there, That's all. It's only when you don't make disclosures that this whole thing will happen. Which is why, working with investment banking, your English knowledge should be extremely good. See, many of you may be thinking of getting into investment banking, share market. English is very important for that. Not ordinary English, a certain level of English, so that you can twist words in such a way that they will mean something, but the other person understands in some other way. Okay, thank you for that, Guru, and all that. So nice of you. But quickly, because that's all. See, once private placement is over, I want to discuss some questions on Prospectus allotment. If once the questions are discussed, that's all, topic over. We can as well go on with our life. So we come to section 42, which is the last section, which deals with private placement, right? So private placement is a way of raising capital that involves the issue of securities to a relatively small number of select investors. So in public offer, you are going to the whole public of India, everybody in India, right from Modi ji to ordinary Srikanth, everybody. But private placement is you're going to make an issue to a relatively small, means comparatively less number of people. That too, selected number, selected people. A private placement is different from a public issue in which a private placement is different from a public issue in which securities are made available for sale on the open market to any type of investor. Okay, public, that's what I told now, right from Modi ji to ordinary Srikanth, everybody will be given the offer. Everybody can apply also. See, in a public issue, you cannot say anybody with the name of Srikanth cannot apply and all. Anybody can apply. You cannot say Srikanth cannot apply, get out like that. No, you made an open offer to the public. I mean, maximum what you can do, there is an oversubscription. Thereafter, allotment can be done only proportionately. That also is controlled by government, by SEBI. You can't simply say, hey, don't allot to Srikanth and all. You cannot say. SEBI will decide. Whoever has applied for 100 shares, give them each 10 shares. So minimum 10% everybody should get. That is what they will say. Depending on the oversubscription. Suppose 4 times oversubscribed. Then they will say, for every 4 shares, 1 share allot. Some logic they will give. So even though I applied for 400 shares, I will at least get 100 shares. Okay. That is public issue. Whereas in private placement, it is going to a select group of people. I have an option. I can decide not to allot also. So many things I can do. So offer should be made to a select group. Select group means you can say selected group. A group of people who are selected from your relation and friends and relatives. The number of persons should not exceed 50 or such prescribed number. Okay. So, Rule 14.2 has prescribed 200. Please understand, Section 42 talks about 50 or such prescribed number. The section uses the word 50, but rule has prescribed 200. So, now which is correct? 50 or 200? Listen to me. Don't have any doubts. 50 is not the correct answer. 200 is the correct answer. You have understood? Number of persons should not exceed 200 because section uses the word 50, but central government has power to prescribe higher number. The central government has prescribed 200. So, now this number is 200. Okay. So, thank you. I'm going to have water. Now, very important. You remember, for private limited company, for the purpose of number of members limited to 200 visa, that is why 200. See, remember, private company maximum number of members is 200. That is why here they have made it 200. So, private company can also go for private placement up to 200. Got it? Now, you will ask me very correctly, why, sir, these fellows, in the section itself, why they cannot put 200, sir? It's a good question. Why in the section itself, let them put, why put 50 in section, 200 in rule? Hey, MCA likes to do things like this. They enjoy this type of confusions. If they don't do it only, we'll be surprised. If they do something straightforward and clear, we'll be very, what happened? It will start raining that day in whichever, in Delhi, it will rain. Cats and dogs, because the Ministry of Corporate Affairs actually giving reasoning, explanation, logic and doing something. Oh my God. It's a totally unheard of incident like that. Okay. Okay. I was also thinking about GDR, Global Depository Receipts. Earlier, it was not in the syllabus. So I have left it out. Don't worry. When I cover share capital and debenture, I will cover section 14. Sure, I will cover. Thanks for pointing out. I made mistake only again. Because you see, the institute material was amended. Believe me honestly, I'm not trying to give an excuse. I was busy with my, 31st October, all the return filing and all that. This time it was a little bit of a mess. So I could not work on it. So I will, 41 I will cover. If it is earlier, 41 was not there in the syllabus. Now they have included 41 in the syllabus. So I will cover that also. No, it will be covered in the next class. Don't worry. Okay. It's not a big thing. I will explain what is GDR, but I will also cover what is there in the material on Sunday's class. Before I start SCD, I will cover QIB and I will cover 41 and I will. So, really, this time today, I'm very happy. So, section 41, if it is covered in the material, I will definitely cover. Earlier, it was not in the syllabus. 41 was not in the syllabus. The following shall not be considered for calculating them. You remember there we went to private limited, there we had 200. Now, for that, we did not include employees. Do you remember? And past employees who at the time of becoming a member were employees of the company. Past employees. So like that here also they are exempting two categories. QIB, qualified institutional buyers, who are QIBs. These are, see, remember QIBs we saw when we read red herring prospectus. Do you remember? These are big banks, mutual funds, asset management companies, investment companies, which have a high capital net worth. They make huge investments. The business of these QIBs is to make investment in companies and make money. Venture capital fund, FII, foreign institutional investor. They are all coming under QIB, qualified institutional buyers. How do I know who are all qualified institutional buyers? Go to SEBI website or search in Google QIBs. Immediately you'll go to SEBI website and you will get the whole list of registered QIBs. They are all registered with SEBI. So what happens now when I go for private placement, I might go to a QIB also. I might ask the QIB to get. So when I'm making offer to QIB, for calculating 200, QIBs are not to be included. Okay, some of you might have got confused. Suppose a private limited goes for private placement. The total number of members cannot exceed 200. Are you able to understand? Including QIB. Because the number of members of a private company cannot go above 200. But suppose public company is making a private placement, then while counting 200, QIBs need not be included. Without counting QIB, you can go up to 200. Also, employees who are given securities under the employees stock option schemes, employee stock option scheme, they will also not be included. So some of you may have a doubt. That is why I'm giving this explanation. Private company, the limit is 200. Of course, not including employees. So employees can be anyway excluded for private also. QIBs will be included in the 200 for private. But for a public company, when they go for private placement, while computing 200, you can ignore QIBs. You can ignore employees being offered under ESOP. Only ESOP is exempted here. Whereas for private company, any employee is exempt. Okay. Why should you return not exceed 50? Because it is there. Gunjan, what are you reading? Did you listen to me? In the section, it says 50. In the rule, it has been increased to 200. So the correct number is 200. It is exactly for people like you only. I explained it 100 times. Why it is not 50 and but why am I putting 50 here? It is there in the section. I have to put it here. Okay. But the prescribed number is 200. I have put it very clearly in the slide. See, private placement is not a deemed prospectus. Deemed prospectus we have already covered in section 25. Okay, covered in section 25. Right. This is private placement is not a deemed prospectus. But there is one case law which is reported in the institute. There is one case law which is reported in the institute material. It's very interesting case law, which is very, very crazy case law. This case law is there in your material, page number 3.9 of the material. Page number 3.9 of the material. It is SEBI versus Kunnamkulam Paper Mills Limited. Kunnamkulam Paper Mills Limited. See, deemed prospectus, they are telling, for deemed prospectus, they are telling where a rights issue is made to existing shareholders with a right to renounce in favor of others. If the number of such others exceeds 50, it also becomes a deemed prospectus. See, when this case was filed, it was filed sometime in 2013. That was when the act had been just passed. At that time, this number was 50. At that time, this number was 50. So, what has been decided by the Securities Appellate, by the Kerala High Court at that time is where a rights issue is made and that there is a renunciation offer. See, what will happen now? Suppose you are making a rights issue to your existing shareholders with a right to renounce. If the number of those other people who are getting is exceeding 50, that also becomes a deemed prospectus, they are telling. There is a connection between private placement and deemed prospectus. Because why in Kunnamkulam Paper Mills case, why they use the word 50? Because if it exceeds 50, see, up to 50 outsiders can be allotted. Because in those days, this limit was 50. So up to 50 private placement was allowed. But the minute it exceeds that, other persons will exceed. See, members, no problem. Members, you can allot fresh allotment, no problem. But suppose there is a renunciation. The number of people to whom renunciation is made cannot exceed 50. Okay. At that time, please, Gunjan, please listen. At that time, in 2013, it was 50. That rule 14.2 had not been prescribed when this case was filed by SEBI against Kunnamkulam Paper Mills Limited. Okay. There, that company had made a rights issue where renunciation was there. The people, see, the shareholder, instead of taking the share, he is giving it to another person. That total number exceeding 50. Therefore, the SEBI has said you have violated private placement norm. Whatever document has been sent by you, will now have to comply with the prospectus. This is what they mean here. Now you understand? If the above limit is breached, okay, if the above limit is broken, if you are giving more than 200, then offer for private placement made, whether by a listed company or by an unlisted company, to more than the number of prescribed persons above shall be deemed to be a public offer, not deemed prospectus. Okay? Not deemed prospectus. It's a public offer. Okay, that's what deemed prospectus. There is no deemed prospectus for private placement. Deemed prospectus is section 25. Here they are telling deemed prospectus, deemed to be a public offer. The minute is deemed to be a public offer, then that document, that offer should be in the format prescribed under section 26. Part 1 of chapter 3 relating to content of prospectus, etc. will apply. So if a company makes a private placement offer, not including QIB employees under ESOP, if the number is more than 200, then straight away that offer will become a public offer, and that document by which you are making private placement should comply with the requirement of prospectus. Okay. One more thing, very clearly, section 42 says the private placement offer and application shall not carry any right of renunciation. Okay, shall not carry any right of renunciation. Means in a private placement offer, only the person to whom the letter has been sent can apply. He cannot in turn transfer it to anybody else, right? Whereas, please see, in private placement, there is no right of renunciation, right, sir? In rights issue, I go to my existing members and I tell them, boss, I have to give, you are already holding shares. In proportion to your existing shares, I'm giving you fresh. You take it. If you don't want to take it, within the next 15 days, you pass it on to anybody. Let him apply, I will allot. This is called right of renunciation. In private placement, there is no right of renunciation. In private placement 42, there is no right of renunciation. But in rights issue, there is a right of renunciation. Kunnankulam paper mill is for rights issue. And seriously, I'm confused. Why are they including 50 there? I don't know. Because 50 is the limit for private placement. There is no limit for renunciation. Are you able to understand? What they are telling, see, this Kunnamkulam case, I'm totally confused. What they are trying to say, you make a rights offer. If your existing members apply a lot, no problem. But the minute they are renouncing it, and that number to whom shares are announced, fresh people are coming, that number, listen to me, Gunjan, you are first person to understand this. Now it is 200. At the time when Kunnamkulam was decided, it was 50. Now it is 200. So if I am making a rights issue now, and my members are taking it, they are not buying, they are passing it on to other people. Those other people are getting more, that number is more than 200, maybe 250. Then it automatically becomes a public offer, deemed to be a public offer, not deemed prospectus. It will be deemed to be a public offer. But here they are unfortunately using the word deemed prospectus. Because if they say deemed prospectus, it will go to 25. But in both cases, it is not going to make a big difference whether it is deemed to be a public offer or whether it is a deemed prospectus. What is the basic point? That document, that communication, that notification, that circular by which you are informing the people now, it should comply with part 1. That means up to section 40. It should comply with all the requirements of prospectus. In case there is any misstatement, liability will be there. Everything will be there. It will be treated as if it is a public offer if the number exceeds 200. Now, I am explaining Kunnankulam paper mills to you. Why? Because they might ask in the exam like a problem. So, I don't want you to be confused. Company makes a rights issue. Renunciation is possible in rights issue. The number of people to whom renunciation is made exceeds 200. Then, according to the Kerala High Court, it will be treated as a deemed prospectus. That's all, matter over. The law, I am not happy with the Kerala High Court decision. I don't think it is deemed prospectus. Right of renunciation is part and parcel of my preemptive right. If it exceeds 200, what? Except that private company cannot have more than 200. Yeah. That much I can tell you. Private company cannot have more than 200. The public company rights issue, I seriously don't see anything, but they have decided like this. So, see, only when there is a contradictory view, the case law becomes relevant. For something which is already there in the section, you don't need a case law. Only when there is some clarity or confusion given by the High Court, you have to obey you have to remember the High Court decision. Okay. Are you clear about this Kunnamkulam case which is there in your Institute material? Yeah. See, I am not saying, you can ask me, how can you say High Court is wrong? I am not saying High Court is wrong. I'm saying I wish they had been a little more clear in the way they passed that order. Because the problem, that's what I'm saying. There's a difference between deemed prospectus and deemed to be a public offer. One more thing, private company does not, private placement, there is no right of renunciation straight away. Yeah, there is something called global depository receipt, which is very short and sweet. I will cover it in my next class. Not a big deal. I will cover it in my next class, or if time permits, today itself, I will cover it through the Institute material without PowerPoint. I will cover it, and you can use the Board of Studies material for that. Easier. 2 minutes, I will cover it. It's hardly 1.5 pages. It's nothing great. This is global depository receipt. I'll cover it. Okay. Now, procedure for private placement. Private placement to be previously approved by private placement to be previously approved by a special resolution for each offer. One more thing, did you notice it? The above limit of 200 is for separately to be reckoned for each kind of security. For example, I'm going for private placement, equity, 200. Preference, another 200. Debentures, another 200. Got it? 200 equity, 200 people preference, 200 people debentures. Separate. The limit is separate. It should be made separately for each. Alag. 200 alag, 200 alag, 200 alag. Equity, preference, debentures. So each type of security, you can have another 200. Private placement to be previously approved by a special resolution. Explanatory note for special resolution to provide information, including justification for price and details of valuer. Still some protection is given to the applicant so that the price should be justified. How are you charging this? Some valuation should be there. That valuation report should be kept and the details of valuer should be given. Who is that valuer? Etc. And the value of such offer or invitation per person shall be within an investment size of not less than 20,000 rupees face value. Please note it, my dear friends. Suppose I am making an offer. Suppose I'm making an offer of 10 rupees share. 10 rupees share at 200 rupees. 10 rupees face value. 10 rupees face value. 200 rupees price. 10 rupees face value. 200 rupees price. Now what will be the 10 rupees face value, 200 rupees price. Now, what will be the total value of the shares? What will be the total value? 10 rupees face value, 200. Suppose 20,000 rupees. 20,000 rupees face value divided by 10. Okay, gets me 2,000. So, minimum number of shares should be 2,000 into per share 200. Minimum 4 lakh application. How I got this calculation? Minimum should be 20,000 face value. Face value is 10 rupees. Therefore, per person minimum, they have to apply for 2,000 shares. One share price, including premium value, is 200. So, each person should be ready to invest a minimum 4 lakhs. Minimum 4 lakhs. Less than 4 lakhs, not allowed. I hope this calculation is clear to you. How I made it. Okay. Now board resolution is, so for equity and preference, you have to go for special resolution. For non-convertible debentures, means at the end of the period, they will be redeemed. They will not be converted into equity. For those type of securities, board resolution alone is okay. Non-convertible debentures, where the amount does not exceed the limit prescribed under section 180. See, section 180 is not in your syllabus. It is in the powers of the board. Okay, 180. It will come in final. When you finish your final exam, self-paced module, you will study company law. There you might want to study 180. Right now, for the sake of knowledge, because the 180 is mentioned here, 180 is the limit on the powers of the board, where the amount to be borrowed, with the plus amounts already borrowed, amount to be borrowed plus amounts already borrowed, total exceeds, will be equal to or more than 2 times the net, 2 times the paid up capital and free reserves. See, if it is going to exceed the PC, paid up capital and free reserves. See, my paid up capital and free reserve value is 100 crore. My paid up capital total, free reserve total, 100 crore. Now, my debt, total borrowing should not exceed 200 crore. Suppose the new borrowing together with the existing borrowing will exceed will exceed the paid up capital and free reserves, then, I'm keeping on going to 2 times. My paid up capital and free reserve is 100 crore. My borrowings cannot exceed 100 crores under section 190. That is a limit, which is the paid up capital and free reserves. Suppose the amount to be borrowed through this NCD, along with the amounts already borrowed, will exceed paid up capital and free reserves, then I have to pass a special resolution under section 180. Therefore, so long as the amount does not exceed 180, board resolution is sufficient. But if the limit of 180, which I told, total of paid up capital and free reserves, if the total borrowings plus this borrowing will exceed paid up capital and free reserves, then you have to pass a special resolution, right? Where the amount of NCD exceeds limit, a single annual special resolution is sufficient. Suppose every year you pass one resolution authorizing the board of directors. You can borrow by issuing non-convertible debentures up to 20 crore. Go on. Even though the amount to be borrowed will exceed the paid up capital and free reserves. Go ahead. So such a single annual special resolution can be passed where the amount of NCD exceeds the limit. Right? So 180 is not in your syllabus. It is just meant for... see, when I'm giving some calculation like this now, you should write down my numbers. Then it will be easy. First write down. Nominal value of share, 10 rupees. Nominal value of share, 10 rupees. So, based on face value, nominal value. Face value of share, 10 rupees. Minimum application should be for 20,000 rupees face value. The law says, every person to whom I'm making this offer, private placement offer, minimum they have to apply for shares on which face value is 20,000. So, face value of this share is 10 rupees. So, how many shares I have to apply? Concentrate on what I'm saying, Swatiji. 20,000 divided by 10. How much I am getting? 2,000. Right? Value of the share, meaning price of the share. Public, I'm giving the share. Obviously, I won't give it 10 rupees now. I have to evaluate the company. That valuation per share comes to 200 rupees. Minimum, how much shares to apply? 2,000. 2,000 into 200 is equal to 4 lakhs. This is the minimum amount. This is the minimum value that that person has to apply. Okay? This is how we calculate. The minimum, that is the minimum investment size should not be less than 20,000 rupees of face value. So face value 10 rupees. 20,000 divided by 10, 2,000. Market, the price at which I'm giving is 200. So amount to be paid is 200 into 2,000, 4 lakhs. Swatiji, have you understood? Kindly Confirm that you have understood. Because you wanted me to explain again, and I have explained again. Kindly confirm to me that you have understood. Okay. Now, some more procedure. A private placement offer cum application letter shall be in the form of an application in form PAS4. Form PAS4 is an don't please explain form PAS4. It is a form. It's a form of an application. That's all. Just remember PAS4, format of application letter in private placement. That's all. Okay. How that format will look? Go to the MCA website, go to PAS4, you will get it. Just keep looking at it. It's a form. It is an application form, Baba. What it will have? Name, PAN number, blah, blah, address, email ID, mobile number, like that they will ask. KYC names and all. That's all. It is an application form. Okay. There is nothing great about it. Now that in the form of an application in form PAS4, it should be serially numbered and addressed specifically to the person to whom the offer is made and shall be sent to him either in writing or in electronic mode, meaning email, within 30 days of recording the name of such person. See, a register should be maintained. In that register, you will enter the number of people, should not exceed 200. Then once that name is entered in that register, recorded, from that day, within 30 days, you have to send it. Okay. Please note, no person other than the person so addressed in the private offer shall be allowed to apply through such application. Why? Because the minute I say anybody else can apply, what I will do? I'll simply type out 200 letters, send it to a few, to 200 brokers, and then tell them, boss, you take this application, send anybody I will allot. That is nothing but public issue. So no, if I'm addressing it to Mr. A, only A can apply. B cannot apply. Even A's son cannot apply. Okay. Complete record of private placement offers should be maintained in form PAS5. PAS5 is nothing but a register. It's a register. So that list of people, 200 will be entered, name, address, everything will be entered. So that is very important. Why? Because once you send that PAS4, then they will apply now. Within 30 days, you should send it. Then they should apply. Okay. Allotment should be made within 60 days from receipt of application money. So once money is received, within 60 days, you have to make an allotment. If there is no allotment within 60 days, then the money should be repaid within 15 days of expiry of 60 days. In case there is a delay beyond 60 days, then you have to pay interest at 12%. So you have to make allotment within 60 days or failure to be repaid. On failure to repay, you have another 15 days to repay the money. If you don't repay, then right from the first day, you have to pay. Beyond 60 days, whatever is the delay beyond 60 days, you have to pay. So I record the name of the person. I send it within 5 days to that person. That person sent me the money. From the date of receipt of application money, 60 days I have to count. Within that day, I have to allot. I don't allot. Then I'm having another 15 days to pay the money back to him. I'm not paying. Then, whatever is the delay beyond 60 days, I have to pay 12%. Right? The return of allotment in form PAS3. Do you remember? Return of allotment is common. Private placement, public issue, everything. Return of allotment is common. Okay? That should be filed with the registrar within 15 days. Monies means money, not to be utilized unless allotment is made and return of allotment is filed. Now, no fresh offer unless allotment has been made on earlier offer or invitation or the same has been withdrawn or abandoned. So what you should do, you should enter the name of the person. Within 30 days, send an offer letter, wait for some reasonable time, then send another letter to him saying the offer is being withdrawn. Then you can make fresh offer to another 200 people. Please listen to me. You can make a fresh offer to another 200 people. So I made one offer to 200 people. Some applied, some did not. Whoever has not applied, I have withdrawn the offer. Now I can make a fresh offer for another 200 people. Got it? Fresh offer can be made, but only you have to make allotment on the earlier offer or that earlier offer to be withdrawn. Only then you can make fresh offer. Have you understood? You cannot give public advertisement or even press meet. You cannot have a press meet and say Dubakur Limited is going for private placement of shares. No. That amounts to public announcement. Nah, you can't do that. Okay. The offer or invitation for subscription of security cannot be made to a body corporate incorporated in or a national, that is a citizen of a country that shares a land border with India. This is a recent amendment, and so certain countries have been identified which are having land border with India. Pakistan, China, Myanmar, Bhutan, Nepal. Bangladesh has no border other than India. See, all countries will have border with two countries now. One on this side, one on that side. Bangladesh is the only country which has no other country in the border, only India. You get in from West Bengal, you will get out in Assam. You get in from West Bengal, you will get out in Tripura. Same India only. You will go in from India and come out in India only. I have been to Bangladesh, I know. So from Chittagong, you go all the way, you will go to Tripura. From Tripura, you have to cross over. That's all. So, or else you have to go to Assam, Guwahati. I mean, Assam and then Guwahati. Wherever you want to go, you have to go. Only India, you will come out. No other country. Or else you go south, you will hit the Bay of Bengal. That is all. Nothing else. Okay. Sorry, I'm not trying to make fun of Bangladesh, but look at this country. It has no, but because of this country, to go to from Kolkata to Guwahati, the train has to go right round this. It can't cut in straight into Bangladesh. Look at the India map, you'll know what I'm talking about. Okay. Anyway, the idea is just for sake of knowledge, I think. See, we are having suspicion about these countries and that our national interest is being affected. Therefore, very clearly they are saying, see, mainly money laundering is involved. Pakistan, China and all, they are floating companies in India and then they are investing. So such private placement invitation cannot be made or subscription cannot be made by body corporate incorporated in or a national or citizen of a country that shares land border with India. Okay. You can, unless that body corporate or national should obtain a government approval under the FEMA, which is again will be sent to the Ministry of Home Affairs, and they will see who is this Chang Wang Kun, and then only they will find out about him, whether he is the Interpol list and all, then only they will give the permission. Otherwise, they won't give the permission. Now, Matsya Hotels Limited made an offer of 50 lakhs equity shares of rupees 1 each to 150 identified persons on private placement basis. 150, no problem. And accordingly, a letter of offer accompanied by application form was sent to them after fulfillment of due formalities, including passing of special resolution. One of the applicants is Mr. Ghanshyam Vyas. He made a written complaint to the company stating that the offer letter was incomplete as well as illegal as it did not contain renunciation clause, as he wanted to exercise his right of renunciation. So he wanted to renounce it in favor of one of his sons, Mr. Radhesham Vyas. Okay. Now, which is correct? So the correct answer is, as the right of renunciation cannot be denied, the company needs to rectify its mistake. No. Company is prohibited from providing right of renunciation. Please note, very clearly they have put private placement offer and application shall not carry any right of renunciation. So the company is prohibited from making right of renunciation. So the offer letter is And the application form need not include any such clause. B is the correct answer. Beautiful. Suman Goyal, highly intelligent person. Beautiful. Swarup Sahaya. Okay. Srinivasan Venkatraman wants to know how we got 200. So 200 I have given, sir. In my example, 20,000 alone we are taking from here. I am telling you that the face value is 10 rupees. So we got 2,000. I am telling you that the value of the share is 200. I am telling you. It is not derived. I am telling you. If I tell you that 200 is the face value, you will multiply by 2,000. How I got 2,000, I can tell you. 20,000 divided by the face value, 10 rupees, 2,000. I am telling you that the face value of the share is, the price of the share is 200. So that I am telling you 200, now you multiply by the 2,000, you will get 4 lakhs. Got it? It is not derived. I am telling you. As part of the problem, information given to you is the market, the price at which the shares are sold is 200. It is information given in the question. Got it, Mr. I think you are S. Venkatraman. I think you are. I don't know. Because in South, our names have this problem. I am Sridharan Srikant. My father is Sridharan. I am Srikant. So S. Srikant or Srikant is. So I don't know whether you are S. Venkatraman or V. Srinivasan. Seriously. So here the answer is B. Now, why I keep on stressing, I am giving you, because I am telling this problem orally. Suppose I, like this, suppose I have written on the board, it will be easy. You won't be asking me this question. So that is why I am telling you. Some information is given in the question. Some information we have to derive by applying our knowledge of the law. See, you ask me question, it is given, I think it is there in the rules, yeah. I am seriously not aware, man. It is there, don't worry. It is given in the rules. It is given in the rules. Okay. If you want, you go to the rules and check it up. Seriously, Manish. I just don't have the energy to verify and tell you. Okay, it is there, don't worry. Okay. Just give me 1 minute. See, once again. I'll check up and I'll get back to you on this. That's it is Institute Ka material. It must be there. I've taken it only from the rules only. 1 second. Somewhere it must be there. 60 days. 1 second. Must be there somewhere. Check it out. Yeah, I understand why you are getting tensed. Because it is not there in your Board of Studies material. You are getting very worried. Okay, I understand your fear that this Srikant is telling some nonsense. How I can believe that? I understand. I will verify and I will get back. In the next class, before I begin the class, I will tell you. Oh, you are Mr. Srinivasan B. Thank you. So because suppose I am telling your name as Venkatraman, that is your father's name. I should not tell that now. So you are Mr. Srinivasan. Welcome, sir. So private placement, in case there is any default in filing return of allotment. You have allotted, private placement is pakka, there is no mistake, but you have not filed return of allotment. Nah. For that, there is a penalty of 1,000 rupees per day with an upper ceiling of 25 lakhs. If you make an offer and accepting money in contravention of Section 42, then the company promoters and directors, everybody is liable. And the amount of penalty is the amount raised or 2 crores, whichever is lower. And the amount received is to be repaid within 30 days of imposing penalty. So this is the amount, which is why you have to be very, very careful while coming to this. Also, Nagaraju, I'm able to understand your typo error. You also were talking only about deemed public offer. Okay. Rutraj Honmane is correct. Same thing they have done in small company also. There they will put 50 and all, and then they will make it 400, 4 crores, everything. The rules only they will do. Okay. So don't worry. Today some people have raised some queries which I have not answered, which I will answer it. In case private placement is made in contravention of this section, we already saw it will be deemed to be a public offer with associated legal consequences, meaning if there is a misstatement, all the penalties and punishment will come. So, as I told you, today you have raised some questions to me, which I could not answer. One is, what is specified security and 25% of it? So, I am informed that there is something called 25% of, in case of specified securities, the minimum subscription is 25%. So, I will take it on advisement and I will answer that question. Definitely, I will answer that question. Also, dematerialization, when I take up, I will discuss that circular of MCA circular of recent circular of 2710. Okay, I will discuss. Also, 447, the word up to or not, I will confirm. And section 41 needs to be covered now. That alone, what I will do, Abito, I will just cover it. Was Global Depository Receipt, GDR. What is it? Now, a company needs dollar or euro. Now, it can, of course, take borrowings through external commercial borrowing, or it can issue shares in INR to foreign institutional investors. So the foreign institutional investors, portfolio investors, they can directly subscribe for shares in an Indian company. So they can become portfolio, they can invest in, as an investment, they can invest in not, see, FDI is different, foreign portfolio investment is different. FDI is where they want to do business in India, they become joint venture partner or they form company and all. Or they simply want to invest in Indian market, they can do so. They can buy the shares of a company. So this company will allot shares to the public, foreign institution. These are all methods. But sometimes a company may not want INR. It may want dollar or it may want euro. In which case, what it will do, it will directly make an issue of shares or bonds in that foreign currency. This is called global depository issue. Now, let us say that Indian company, for example, Reliance Industries Limited wants to raise 200 million euros. Maybe it wants to invest it in some other country. So it needs euro. So it goes for a euro bond. This is called global depository receipt, euro bond. Now, for that, there are certain conditions. Okay, you have to comply with them. These conditions are given in the Foreign Exchange Management Act. Okay, so, but in the Companies Act, they have passed section 41 to enable an Indian company, because Companies Act is the law for companies. Now, so here 41 empowers a company may issue depository receipts in any foreign country after passing a special resolution in its general meeting and subject to such conditions as may be prescribed in the Companies Act, companies rules. So there is a separate issue of global depository receipts rules, which has been there. Now, please note, this is in addition to the FEMA guidelines, Foreign Exchange Management Act, where there are guidelines on GDR, global, in the foreign direct investment policy, there is that. Under the MCA, the procedure is laid out. So what is one procedure? If you want to issue global depository receipts, what are they? They are bonds. See the definition of GDR. GDR means you can take page number 3.45 of your Board of Studies material. See, I am using Board of Studies material itself to teach you. What is that? Of course, I can always reproduce this in the slide and give it to you. Doesn't matter. It is there in your Board of Studies. So, what is more important is the explanation I am giving you now. So that you listen to me, which is, what is GDR? Any instrument in the form of a depository receipt. Because depository receipt is nothing but bond or debenture. You give me money, I give you a piece of paper saying, I owe you, with interest I'll pay you. That piece of paper is called depository receipt. One, that I may not give you a piece of paper, I will create a dematerialized record for you, and just like mutual fund. So instead of giving you a paper, I'll give a statement, your account with me. Therein clearly you will find against the name of whoever wants now, who was asking about 41, whoever asked about 41, Suman Goyal, let us say, Mrs. Suman Goyal, 200 GDRs will be Each GDR will be worth, say, 100 euro, whatever. So you would have paid me 100 euro. Now, this is where the method, see, it is expressed in foreign currency. Okay, created by a foreign depository. The foreign depository receipt will be expressed in a foreign currency. Right. Now, obviously, if Dubakur Limited wants to issue Euro bond, when they go to Germany or they go to France or Spain and say, we want to issue Euro bond, what is your name? Dubakur Limited. Now, they may not trust it. So what they have to do? They have to go to a European bank, some well-known European bank, okay, Bank of France or something, and they have to beg them, please help me to go for a GDR. So that French bank or the Belgian bank or the Swiss bank, they will certify the global deposit receipt. They will guarantee to the people of Netherlands or people of Belgium or people of France, Dubakur Limited is known to us. We have done a due diligence. We have verified with their government also, Reserve Bank of India, clean as good. So you can buy. So they will give. Also, they will issue the foreign deposit receipt and they will pay the interest. Back to back, one Indian bank will give a guarantee. So that this company has to approach an Indian bank and give a back to back, they have to give a guarantee. So that whatever happens, the European public will not lose the money. Got it? Now that money which is collected, now it will be given to this company. They can use it for, obviously, see, if Reliance Industries Limited wants to go for a foreign acquisition, they want to buy out a foreign company in Germany, for example, then they need euro now. So this euro can be used to make that investment, acquire that company. Whatever money is generated, they have to bring it back to India. All these conditions are there. Okay. So this is called global depository receipt. From a company law perspective, what I will try to remember, if a company wants to issue global depository receipts, they should pass a special resolution in general meeting. It is governed by this. How the GDR operates, I told you now, there is an Indian company. It issues equity shares to a domestic custodian. Who is the domestic custodian? A bank or investment bank in India. Now, that domestic custodian enters into a custodian agreement with the overseas depository. This overseas depository is another bank in Europe, well-known bank. And that overseas depository and the Indian company will have a depository agreement. Overseas depository and domestic custodian will have custodian agreement. Under the custodian agreement, the domestic custodian, the bank in India, will swear and say, if anything happens, I will pay. For that, they will collect a fat fee from the Indian company. Fat fee, every year they will collect it. Because they are guaranteed, almost a guarantee they are giving there. Okay, foreign guarantee they are giving. And that Indian company will allot the equity shares to domestic custodian. The domestic custodian is exactly a custodian. They don't become owner of the share. They will be owning the share as a backup. Now the overseas depository will create entry in the electronic register for the overseas investors. The overseas investors will give their money to the overseas depository. All that money will be credited into the account of the Indian company in the foreign country. That money will be, so obviously, if I collect in euro, am I a fool to convert it into INR? I will straight away use that euro for purchasing the shares of another company or acquiring fixed assets. See, suppose I want to set up a refinery. I'm going to import all my machinery from Germany. Then entire euro amount collected for this project will be given to the German contractor. And the refinery equipment will come and I will start refining and make money. Whatever. See, GDR is a method of funding. Like many long-term sources of funding, GDR. It is equity and not debt. Why? Because when you are issuing GDR through the GDR route, you are not issuing bond. You are only issuing equity shares to the Indian custodian, domestic custodian. The overseas depository is creating depository receipts, okay, and issuing it to the overseas investors. But basically, it is like a share, okay, GDR. The deposit receipts can be issued by way of public offering or private placement or any other manner prevalent in the concerned jurisdiction. Okay. The deposit receipts may be issued against issue of new shares or may be sponsored Again, shares held by shareholders of the company. So they may pledge their shares. Existing promoters may give their shares and say, on this security, please give him a guarantee like that. Okay. So there will be a lot of conditions on all that. The underlying shares will be allotted in the name of the overseas depository, and the Indian custodian will hold it. Now, a holder of a depository receipt may become a member of the company and shall be entitled to vote only on conversion of the depository receipts into underlying shares. Okay, that will be mentioned in the GDR scheme itself. So initially, I will hold it for 5 years. Then this company will get listed in that country. Then we will convert the GDR into shares, and they will get a right to participate in the voting. Until the conversion of the depository receipts, the overseas depository only shall be entitled to vote on behalf of the holders of the depository in accordance with the provisions of the agreement. Okay, so this is the concept of global depository receipt. Nothing new. It has been there almost since 80s. It has been there, GDR. And one second. Any more questions? Mr. Ruturaj Honmane is asking, is GDR a costly method of raising funds? I'll tell you, if you want to issue GDR, I will not bother about cost. I will ask you, what do you want it for? Because suppose you need it for investing in a particular geography, sometimes it may be cheaper to issue in that geography and invest in that geography. So it depends on which country, it depends on which thing, need-based. Sometimes it is cheaper, but normally GDR route is not being preferred by companies. Though such a provision is there in the Companies Act, not many companies. Again, the size is very high. See, under the rules, you cannot go for small amount. The amount to be huge amount. You cannot. So the cost is definitely high. But if you are Sunil, Sunil Bharti Mittal or Mukesh Ambani, why you go? You take that money, invest it, earn money. You are not bothered by exchange rate difference now, because you are earning money in euro, paying in euro. You are only caught by the inflation of that country. So it makes a little sense to do it. GDR will not be listed. Once they are converted into shares, the shares can be listed in any exchange outside India. Definitely. On conversion, okay, on conversion, it will be listed. They cannot be listed as GDRs. But basically, you can sell. Means if you are a holder of a GDR, you are a foreign citizen, you are a holder of a GDR, you can sell it to somebody. The local, the overseas depository is there, na? He will take care of the... Agreed. If you feel that it is costly, then kindly advise your company not to do it. But direct listing also you can do. See, today, FDI, overseas direct investment route is very clear. You go abroad, issue shares, which will be listed on NASDAQ. Many companies have done that. You can get your shares listed on NASDAQ. Infosys has done it. Wipro has done it. You can as well do it. Okay. So, as rightly pointed out by Mr. Suman Goyal, GDR is a costly route. I'm totally with you. But still, I am humbly submitting, don't make sweeping general statements. In today's world, in 2023 AD, 58-year-old Srikanth is not willing to make sweeping general statements. This is bad, that is good, like that. Everything is a gray area. I will examine it case-to-case basis. Some cases, GDR might be good. Some cases. I don't want to make absolute statements. In 2023 AD, I don't want to make absolute statements. Nothing is good, nothing is bad in itself. Everything based on situation only, I will decide whether it is good, bad, or leave. Okay, this is my humble view, not as a senior professional, but as a human being who has 58 years of this living in this world. I have learned a lot. Nothing is cut and dried. Nothing is black and white. Okay, a lot of gray. So I'm unable to, I don't have that ability like you, Mr. Suman Goyal, to make absolute statements. This is not correct. This is costly. That is cheap. Like that and all, I cannot make. It may be probabilistically, probably maximum number of times it is costly. But there is still that one black swan running around there. So go and, I don't want to tell you what is a black swan. You are in, all of you, to make you a little more intellectual, You go look up black swan in the Google or wherever, and Tayyab Nazib, you look out and you see what is a black swan. Once you know what is a black swan, you will stop making sweeping statements, because there is that one chance of a black swan. You might say, sir, all swans in the world are white. I will not agree with you. There, even if sighting of one black swan will disprove the statement. Got it? I've already explained also to you. Black swans are the danger. Please remember. Are you able to, later on, you go back and do some research on global financial meltdown, you will understand what is a black swan. When you make absolute statements, immediately people like Srikanth will be starting to worry. Hey, people have started making absolute statements. That means that something is going to go wrong here, or change is there. This has nothing to do with Suman Goyal's statement. In general, to a group of people who want to become highly intelligent chartered accountants and professionals, this comment is being made. Don't be simplistic. See, as future members of the institute and as a current member, we do not have the luxury of making simplistic statements like common people. Everywhere there is a gray area, there is a nuance, there is a change. So very, very careful. Okay. Correct. Black Swan. See, that was Black Swan. It was an Oscar winner. Okay. Correct. You search, yeah. Be intelligently, you search for Black Swan. You will get. Yes. Of course, the Oscar winning movie is also there. Black Swan. It's a beautiful movie. Very good. I'm very happy that Mohin Patel has got knowledge of movies, but still search for Black Swan. Anyway, good. Now, what I'm going to do is, since we still have some 10 to 15 minutes, I have sent one assignment. So I hope you have received that assignment. If you've received it, I'm very happy. I would love to discuss it a little bit. Give you some hints and all that. And quickly I will go. I will also upload the answers. I will also upload the answers. Okay, you need to read the question. This assignment was uploaded by me. This is a case study based question. All along, we were only doing MCQ type of questions. Whereas now we are, for the first time, I want to introduce the concept of a case study to you. So, this Adekar Industries is a company where, I have invented this company and this family. Correct. Beulah has already looked it up and she is putting Black Swan is an unpredictable event that is beyond what is normally expected of a situation and has potentially severe consequences. Usually, Black Swans are never a good thing. They are always a bad thing. Okay. But see, my dear friend, Black Swan can be good also. There is that 1 in a million possibility that you will do something great. Sometimes, I have taken a risk in my life and that risk was a 1 in a million Black Swan. And I have made that Black Swan happen. See, many people have told me, Srikanth, you cannot do it. Nobody has done it. He said, I will be the exception who will do it. And I have gone and done it. So, not necessary that a Black Swan should be a negative event. It can be an unexpected positive also. So, don't think always. But by and large, as commonly understood by human beings, Black Swan is a potentially severe. When the global financial meltdown happened, very few people saw it. Nobody believed it. They said, no. Okay. There's a movie also about it. I forget the name. It's a beautiful movie. The Big Short. The Big Short. I think it's The Big Short. I think so. It's a beautiful movie. It has this guy in it. What's his name? Brad Pitt acts in that movie. It's a beautiful movie. The Big Short. Big Short. SHORT. The Big Short. Because the whole world will be going bullish on mortgage bonds and derivatives and all that. When A few people alone will have the risk to go short on it. And when the entire global financial meltdown happened and the whole markets collapsed, these fellows made money. These fellows alone made money. Okay. So that is how it is. I will zoom it. It's a very interesting movie. Do watch it. You might also ask me, sir, we are all CA students, sir. We don't have time, sir, like that. Agreed. You don't have time, don't watch. That's all. What can I do? Okay. If you want, you watch. You might ask me, sir, will it help me to pass the CA exam? It will. So it will make your answers more intelligent. Some of the extra knowledge that you acquire now, your answers will become more intelligent. The way you write will become more professional. That professionalism will be seen by the examiner when he's correcting your paper. No, while counting 200, we cannot include HNI. Clearly, only QIB is given. So, we'll come to that. Okay. So, only QIB is given and only QIB, no HNI. Okay. So, Adekar Industries was founded by a great man called Mr. Vikram Adekar. Vikram Adekar was born in Pune. He studied from IIT Madras. He joined a leading automobile company, worked for 10 years. Thereafter, he started his own business. In 1996, he founded Adekar Industries, engaged in the manufacture of. There is no such person called Vikram Adekar. It is a fictitious name. But there could be a real man who is similar to Adekar. Okay, but name is not there. Fictitious name. Adekar Industries was initially a partnership firm. The firm did very well and grew on the India Shining Wave. You remember 2005 onwards, 2000 to 2005 was India Shining Wave. And it went into rapid expansion. At that time, new automobiles came into the country, huge demand for automobile components and all that. So they became big. So in 2016, the firm was converted into a private limited company. You will come across this Adekar Industries naam many times in my questions. I love this Adekar family. See, only Vikram Adekar now. If you come to final, I will talk to you about the board of directors where Vimala Adekar is there. Their son Vijay Adekar is there. There's one Vimal Adekar also, which is a dangerous fellow. All that is there. Now in 2020, Adekar Industries Limited was poised for growth and is in need of equity. Banks are very much happy about lending money, provided equity is infused. Equity is bought. Infused means brought into the business. Now, obviously, Vikram has reached this limit. Now, how much money can a man put? So he wants to now go to somebody. So for that purpose, what he does, he has reached the limit of financial abilities and he wants to now look for external investors. A few investment bankers, after studying the financials, have agreed to invest. But Vikram was worried about taking money from a few investors, especially QIBs. So he decided to go public. But before going public, the board of directors made a private placement offer. See, what happened was, Vikram Adekar had a lot of friends from IIT Madras who were very proud of his batchmates and all. And the juniors and seniors, hey, Vikram has done it. Great, yeah, Adekar has done. Let's invest in that business. So when he badly needed money, he went to his own friends and relatives, his batchmates from IIT Madras, and he said, hey, I need money. Would you like to invest in my company? They were so happy to do it. So private placement offer for 50 lakh shares of rupees 10 each at a premium of 140 rupees was made, right? The private offer is the entire amount to be received at the time of application, entire 150 rupees straight. So application was received from all these people. So 135 from Vikram Adekar and friends and relatives, batchmates of IIT 55, employees of Adekar under ESOP 50, QIBs 5. So totally we have 50 lakh rupees. Great. 245 from 245 persons. Okay. Sorry, 50 lakh shares were right. The private placement offer was well received and the application money was received in full. The shares were duly allotted at the board meeting held on 11th January 2020. Please make a note of this date. 11th January 2020. Okay. Right. And the money was received on 15th November 2019. Why are these two dates important? When you come to the question, you will understand. Now, the financial results for 2020 were extremely good, and the company's valuation has been pegged between 210 and 260. Wow, from 150, the valuation has now gone to 210 and 260. So Mr. Vikram Adekar is confused. Should he prefer the lower valuation and be sure of full subscription, or should he go for the higher end valuation, take a risk of under subscription? So Vikram Adekar preferred to follow the advice of his financial advisors and issued a prospectus which did not include complete particulars of the quantum or price of the securities. Subsequently, a regular prospectus was filed, based on which allotment was made on 3rd May. See, regular prospectus is filed. So even though there is a price band, finally a price is finalized based on the bids received. In the meantime, one Sunrise Financial Holdings, one of the QIBs who had been allotted shares in the private placement, made a public offer of their holdings at the higher end price. Okay. The offer, which was not in accordance with provisions of Section 26 as to content, was circulated on 25th April 2020. When were they allotted the shares? Please go back. This date is very important. They were allotted the shares on 11th January 2020. The allotment was made on 11th January 2020. When did this Sunrise fellows go for private placement? When did they go for offering to the public? They offered on 25th April. Why is this date important? Because deemed prospectus, 6 months. Rahul Adekar, who is the first son of Vikram's father's younger brother. See, this Adekar Parivar is very big. Okay. So, Vikram's father's younger brother, cousin, one Rahul guy, he also invested 1,000 as part of the private placement. Okay. And one of the issues claimed by Adekar Industries was they would be able to obtain a defense order for a quantity which was less than 2% of the turnover. The directors honestly believed that this order was possible. However, the order was not granted. Now, this cousin, out of jealousy, Rahul Adekar comes and says, hey, there is a misstatement and I want compensation, etc., etc. Okay, so he comes and starts creating problem. Idea is possibly to ask them to buy back his share at a better premium than market or whatever, something. See, this is the problem. So in the prospectus issued by Adekar, it has been stated that the money raised from the public would be utilized for developing new components for EV, electric vehicles. The company gave proof that it had patents. Now it is proposed to utilize a major chunk for developing solar energy. See, they gave promise of, now they want to do solar energy. Maybe Adekar is right because Adekar is an honest businessman, but still, you raised the money by saying electric vehicle. Now you are saying, I want to go for solar energy. So, friends, I'm also telling you how a case study could be given to you and asked to write. It could be given. I'm not joking. Or a slightly longer problem could be there. So for that purpose, I am giving this. Now, I thought I could finish today early, but it's not happening. Anyway, we'll go through the questions. The private placement offer made by Adekar Industries shall be deemed to be a public offer. And part 1 of chapter 2 relating to contents of prospectus, I've given the offer. Shall apply because it has been made to more than 50. 50 is nobody's number. Shall apply because it has been made to more than 200. Yes, it has been made to 245. Out of the 245, right, 50 are employees under ESOP. QIBs are 55. So 245 minus 55, 190, less than 200. Therefore, the correct answer is shall not apply because the total amount of the offer does not exceed rupees 1 crore. No, shall not apply because it is not in violation of section 42. The number is, see, if it is more than 200, it will apply. But it is less than 200. Therefore, it is not in violation of section 42. Right? The correct answer is C. Now, the allotment made on the basis of the private placement offer is invalid because it has been made beyond 30 days. Is invalid because it has been made beyond 15 days. Is valid because it has been made within 60 days. Check up the dates. Check up the dates. the receipt of the money happened on 15 November 2019. So 60 days. You have to count days. Okay. So 60 days you have to count. So 16th onwards. So 16, 17, 18, 19, 20, 21, 22, 23, 24, 26, 27, 28, 29, 30, 31. 16 days. 16 days plus. I'm very weak. 16 days plus December 31, January, May 11. So allotment happened on 11. So 6 plus 1, 7 plus 2, 9. 4 plus 1. Exactly 59 days. Yeah. Exactly. Possibly they realized that 60 is the limit, and exactly one day before. If it had been 12th January, 60th day, even within 60 days is okay. One day beyond 60 days gone. So this is the 59th day. So it is valid because it is made within 60 days. Okay. It has been made within 60 days. See, because the days is used now, you cannot go date to date. It's not month. It's not 2 months. It is 60 days. So you have to count the number of days and count to 60 and see whether this is within 60 or not. It is within 60. Prospectus which does not include complete particulars of the quantum is called, you know that. It's a, if you have the knowledge, it is called deemed prospectus. Shelf? No. Abridged prospectus? No. Red herring prospectus. Correct. Okay. The correct answer is D. Okay. Beautiful. The offer document circulated by Sunrise Financial Holdings is a deemed prospectus because the offer was made within 6 months. See, you allotted on which day? You made the allotment on 11th January. So now here it is 6 months. So 11th January means 10th. So you have to keep counting till 10th. 6 months you have to count. So February, March, April, May, June, July. So 10th July, midnight, 6 months will get over. When did these donkeys make an offer? The offer was made on 25th April. So February, March, April, May, June, July. So it was made within 6 months. The offer was made within 6 months. That's enough. Even if the entire money is paid in full, one condition is triggered. It is made within 6 months. So it's a deemed prospectus because the offer was made within 6 months. Okay. So even though the entire consideration was received, since it is made within 6 months, straight away it becomes a deemed prospectus. Okay. That C is a bullshit. It's not a deemed because it is made by a person other than the company. Nonsense. That the deemed prospectus itself is for a person other than the company. Okay. It is a deemed prospectus because it is made after 3 months of allotment. See here D, the 3 months is the problem. The correct answer is 6 months. Okay. Here, whereas, do you notice one more thing? It says it's made after 3 months. Nothing like that. It should be made within 6 months. If it is made within 6 months, then no problem. If it is made after 6 months, no problem. Money is also received in full. It is not deemed. But here, one of the conditions has been. See that Rahul Adekar case, whether the directors of Adekar Industries are liable for misstatement, they are not liable because the statement is immaterial. Okay. Not liable because Mr. Rahul Adekar did not subscribe to the shares based on this. That is also a correct answer. Okay. Even if you say it is not immaterial, then definitely Rahul Adekar did not rely on the prospectus. He applied in the private placement. Am I correct? Rahul Adekar was part of the private placement. Part of the private placement. So he did not rely on the prospectus. Sorry. Private placement. He did not rely on the prospectus. So he can as well go under Peak versus Gurney rather than Derry versus Peak. If you go through Derry versus Peak, then you can give B. Peak versus Garni, you can do C. Okay. Now the utilization of the money. See, but I go for peak versus Garni because, see, today this whole he did not rely on the prospectus thing is becoming slightly thing. Because that letter which was sent to these people, it might also have mentioned it. So though it is not a prospectus, it might have mentioned it and Rahul Adekar might have read it. But definitely it is immaterial. And therefore going by Derry versus Peak, it is immaterial and it need not be taken. Okay. And the utilization of the money raised on the public issue for an object other than that stated in the prospectus is not permitted. No, that is not right. Is permitted if special resolution is passed and dissenting shareholders are given an exit option. That is the correct answer. Is permitted provided the approval of central government. No need for any approval of central government. Here the D is wrong because it says ordinary resolution. Whereas the correct answer is special resolution is passed and dissenting shareholders are given exit option. Then you can change the purpose. Right? So there are some more questions here, multiple choice, which you can go through. I'm not going to answer this. Why? Because I'm going to give you the pleasure of answering on your own. The assignment has been uploaded later on Monday. Please listen to me on Monday because tomorrow I'm very busy. Tomorrow morning to night I'm having commitments. I'm speaking at 2 venues in the evening and in the morning I'm having my advanced MCS class program in SARC. So I need to be, I will not have time. Sunday, dark tired, last 3 days. Today I was back-to-back corporate training. Yesterday, back-to-back corporate training. So I need to rest on Sunday. Monday morning, I'll ask my secretary to upload the MCQ. If possible, tomorrow I will do. Otherwise, on Monday, 100%, you will get prospectus and allotment of securities and the answers to the assignment questions. Okay. Exactly 9 o'clock, which is the time appointed for our closure. And wonderful evening. I mean, though I'm saying I'm dog tired now, the minute teaching starts now, I'll become very fresh. And I have no problem in that. So, tomorrow very tight. And I may not have time to do it. That is why. If I have time, I'll do it. Otherwise, Monday, 100% I will. Or even Sunday. At this rate on Sunday, if I'm a little free, I will do. Because I'm dictating an important submission on Sunday. So, with my manager is coming. So, Sunday, that is why I humbly request that I may be permitted to upload it on Sunday. On Sunday evening, we have a class. So, kindly do not put message on the board saying not uploaded, not uploaded. It may not be uploaded. On Monday, it will be uploaded. Okay. See you. Have a great evening or rather good night. Bye. Bye. Good night. Yeah. Over. Good night.